All right, here's another great question from Quora. A company that applied for a trademark in July of 2019 is trying to claim a trademark for a domain I have owned since 2003. Is the company able to take me to court over this? My name is Andrei Mincov. I'm the founder of Trademark Factory, and here's my answer to this question. My short answer to this question is this: yes, they can take you to court. Anybody can take anybody to court pretty much with and without a good reason. But that's probably not the question you're asking. What you're really asking is, if they took you to court, what would be their chances of winning? And the answer to that is, assuming that you're willing to put up a fight and don't just give up right away, you would have a very good case that you have owned this domain name long before they filed for the trademark, and that their trademark does not give them the right to take the domain name away from you. Now, there's a couple of additional things that I wanted to mention here. First of all, when they filed the trademark in July and you have owned this domain prior, what you could do, which is probably a good idea for you to do, is to monitor the process for their trademark registration, and when it gets approved by the trademarks office, if it ever gets approved, what will happen is they will publish it for opposition purposes, and anybody, including you, could oppose that trademark, and you would basically say to the trademarks office, please don't let them register this trademark. It's my domain name. I've owned it since 2003, and they do not have any legal right to that name. So that would put them on the defensive, and they will have to figure out a way to somehow show to the trademarks office why they should be able to own this trademark while you actually own the domain name. I don't know what your domain name is, of course, so there may be some special circumstances here, but this is a consideration you should have. One other thing you should consider is that if they do successfully register that trademark, then you would be limited to what you'd be able to do with a domain name. And really, this matters. It's one thing to own a domain name since 2003, and it's a totally different thing to have a website that operates from that domain name. So if all you have is a parked domain name, then you would not have very strong chances against them, because every time you renew your domain name, if there's nothing on it, if there's no other legal interest for you to have the domain name, they would have an argument that the only reason you're holding the domain name is to sell it to them or to prevent them from reflecting their trademark in a domain name. But if you do have an active website, of course, your chances are much, much, much stronger. But even then, let's say they register the trademark. With that, what they'll be able to do is to freeze you in where you are with your brand development, with your domain name, with your website, which means that you probably would not be able to sell the domain name to somebody else, because at that point the new buyer would have to deal with the allegation that, again, they're infringing on their trademark. You wouldn't be able to substantially expand your business activity because, again, they would have the trademark. And so I'll give you an example from my personal story. When I came up with the name Trademark Factory, the .ca, the Canadian domain zone, was available, so I got that, but the .com was taken. And we tried negotiating with the domain name owner. At that point, they asked me for the amount that was more than I was willing to pay. So what I did is I registered the trademark, and I went back to them and said, great, now you have a buyer of one. Nobody else can buy it from you because I own the trademark. And anybody you sell it to, I'll take it away from them using the uniform domain name resolution policy pretty easily. And really, I didn't have to use that because they didn't respond, and they let the domain name expire, so I just got it through the auction for like $60 or something. But we have used this same strategy many times for many of our clients, and it doesn't force the transfer for free, but it does make the domain name owner often more reasonable in terms of the price that they're going to ask, because they understand that they can't sell it to anybody else. So in your case, again, if they get the trademark while you own the domain name, they won't be able to sue you for infringement because you were there first, but they will be able to curtail your expansion. And so if that's a concern, again, the advice is make sure you follow what happens with their trademark application and oppose it if necessary. So I hope this answers your question. I hope this is useful. And if you got more questions, probably for this particular case, better to take it to email. You don't necessarily want to, discuss your specific legal situation in a public forum like this. But if you're just genuinely curious about trademarks, about brands, about entrepreneurship, just post your comment below if you want my answer to that, and I'll try to shoot a video. And until then, I will see you in the next video.